Sure. So essentially, I mean, data protection legislation, which we broadly categorize under the umbrella of privacy legislation, is something that is, of course, required, and more so from the point of view of protecting consumer data. And we've seen how, there have been data leaks and hacks, etc. I mean, in our local context, it's been slightly different, but globally, you see that often, large corporations and companies who hold your data, their systems get hacked, or they're using your data for a particular purpose, and that can be telcos as well. And so you want to be able to protect private data, especially if it's healthcare, financial information, and other sorts of data. So essentially, the aim of any privacy legislation is to extend that kind of coverage to users, to consumers, to citizens in general. Now, there's been a lot of back and forth on privacy legislation in Pakistan as well, in some of the earlier drafts since 2005. Unfortunately, we got a cybercrime law before we got a privacy legislation, and we still don't have privacy legislation. And the unfortunate part with how this is now panning out is that there have been, so every now and then a draft would surface for input, and then it would disappear, and input would be invited, and then you wouldn't know when the cycle is going to continue, what version of the draft is going to emerge. Since 2019, this has been going on and off with the previous setup and the current setup as well. Various companies, industry actors, civil society groups have provided input. The problem is where we are at currently, and the AIC statement highlights that, is that while input has been given, this has been a disjointed process because there's been no update in terms of factoring in some of the substantive concerns that have been flagged by civil society groups and industry groups. And so some of these things that you also mentioned, data localization, cross-border data flow, I would also add, independence of the commission, not having it under government administrative powers, or the fact that, mandatory data provision or certain categories, what you categorize as sensitive data, etc. A law should never be vague, especially also when you carve out penalties, it cannot be discretionary. And this, unfortunately, is what we are seeing with the current version that's before us, assuming that this is the latest version. Apparently now it's also moving to cabinet. So just in terms of how this process is panned out, that you do these consultations, you take input only to check a box, but not meaningfully incorporate it or take the stakeholders through the process to keep them engaged and to let them know where it's at and when it's going to head to Parliament, instead of just alarming people. And they suddenly find out through various disclosures that this is now going to be passed as law. And so the one thing that should not happen is that this version should not pass into law the way it is. Cross-border data flow, data localization are some of the things that the AIC and also Digital Rights Foundation has also highlighted it. There's also a submission by the US Chamber of Commerce and previous submissions that Bolo Bhi has also made, and local industry has also identified certain things. So data localization actually is something that has been attempted through the social media rules as well. This has been a conversation that has been ongoing since the YouTube ban, and essentially this is about gaining more control. So the whole registration requirements for companies to incorporate, global companies to incorporate here, for local laws to be applicable, for there to be access to data. So on the one hand, from a tech aspect, you understand the data localization and the speed and ability to store, etc., is something that you would desire. However, there's an infrastructure requirement you need as well, right? Which we do not have. So, for example, establishing data centers, and what essentially is being asked of global companies is to bring their servers here, to house them here, to provide for access to be provided to the government. And this is something that's not going to happen. They've stated in their briefs that there are certain laws that they are required to follow locally, and this would be a breach of local law if they were to do so. Even when the social media rules were introduced, a lot of this was stated at that time as well. Not only the contravention, but the fact that it's going to be very difficult to continue offering these services in Pakistan. And what you do is essentially, because you become dependent on cloud services and other services, and you've set up businesses and you're relying for information through all of this, what you do is basically force companies to either comply with you or then either stop offering the services. Who gets hurt? The end user. We've seen this with the TikTok ban and the internet disruption that we saw recently. If you are going to pull the plug on services whenever you want, that's not a guarantee that you are providing, and that's an unstable, unregulated environment which businesses cannot function in. It's not also conducive for your users, etc., and it's a breach of rights. In India, there's a lot of criticism right now of the data protection bill that is being introduced there, with very similar provisions, and so we're aping what is being criticized across the border, and that's something that we should refrain from doing as well. So some of these things, especially in terms of access to data, how that data is secured, kept, these are going to be big questions, big concerns, and this has been something that has been consistent with what the government and successive governments want to do. There's this complete control security mindset that we want access to data without any limitations, without looking at any global standards and how this happens. Even under PICA, there are warrants, and here you want to circumvent warrants in a law that's supposed to be protective for users. It's not supposed to enhance the powers of the government, yet this is what it's doing. So again, from what we are hearing, and this is again assumptions, and this should be corroborated, or there should be an official statement by the ministry in terms of where this bill actually lies and what the final version is. But for what we know of now is that it's being sent to the cabinet for passage before the National Assembly. And unfortunately, right now, with the political climate and also how legislation is being done, things are just being passed through without substantive debate. This law, ideally, if it is sent for passage to the National Assembly, it should be deferred to a standing committee. I don't see any substantive discourse happening currently in the present environment. We don't know how long the assemblies are going to be around, when the elections are. They should pull the plug on this for now. There needs to be revision, input, public discourse on the latest version of whichever draft is now under consideration. And when you see the next few months through, that is when a standing committee, through public hearings, getting input from various people, that's how this draft should proceed. It should not become law in the next day or weeks or months in haste, because we're going to end up with a very PICA-like situation.